It abolishes cash bail for almost every offense. This includes, but isn't limited to, kidnapping, armed robbery, second-degree murder, drug-induced homicide, aggravated DUI, threatening a public official, and aggravated fleeing and eluding. Offenders released on electronic monitoring have to be in violation for 48 hours before law enforcement can act. They could almost drive to Alaska before we can even look for them. It denies victims their constitutional rights. And keep this in mind, businesses and homeowners. Officers will no longer be able to remove trespassers from your residence or your businesses. Someone could decide to live in your shed, and all we can do is give them a ticket. You have to decide what level of force is required to remove them and whether or not it's legal. This is a massive threat to the residents.
Have you all heard about this Safety Act that's passing? Well, some of it's already passed, but it's going to go into full effect January 1st, 2023. And they're talking about like second-degree murder, kidnapping, trespassing, all those stuff will be cash non-detainable offenses, and there won't be any cash bail. So, I'm not shocked with Illinois, given the corruption that is in the state, given the way that things are handled by government officials, by judges, by other people. In fact, I even read a comment that somebody said, oh, they should allow judges to decide. I'm going to tell y'all right now, if you think a judge is fair and balanced just because they have the title of judge, you are sadly mistaken. I mean, I hate to break it to you, but our justice system is not a justice system anymore. It's all a political game. I've briefly skimmed through the bill because one of the questions I really have in all of this is how does it affect people who, say, are held in contempt of court, who aren't allowed to have jury trials because I don't know if you're aware, but in family court, you don't have jury trials. Save in juvenile court, there's no jury trials. So how does this affect them? And for the people that are actually sitting in prison right now for threatening, for judges saying that they've been threatened by these people when that's not actually the case, are those people going to be released then? So as I was skimming through, I came across the section about constitutional rights, and that's kind of something that I wanted to talk about because I think that this part could possibly be a good thing. So in looking up this new, what you want to call it, the Safety Plan Act, if you look in here on Section B, it says no governmental authority or agent of a governmental authority or person acting on behalf of a governmental authority shall engage in a pattern or practices of conduct by officers that deprives any persons of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States or by the Constitution or laws of Illinois. So my question is this: does this mean that family court judges, DCFS people, all that kind of stuff can actually be held accountable for violating our constitutional rights? Because if that was the case, that would be really cool. And I know people say that the Attorney General doesn't pick these cases up, but let's go on to read what else it says, okay? It says, whenever the Illinois Attorney General has reasonable cause to believe that a violation of subsection B has occurred, the Illinois Attorney General may commence a civil action in the name of the people of the state to appropriate, equitable, and declaratory relief to eliminate the pattern of or practice. So the question remains, does that include the family court division? Does that include judges? Does it include bailiffs? Does it include all of them? Because according to this, it should. It goes on to say, venue for this civil action shall be Sangamon County or Cook County, so I'm assuming that's where they would take place, and such action shall be commenced no later than 5 years after the occurrence or the termination of. It says, prior to initiating a civil action, the Attorney General may conduct a preliminary investigation to determine whether there is a reasonable cause to believe that a violation of subsection B has occurred in conducting this investigation, the Attorney General may require the individual or entity to file a statement or report in writing under oath or otherwise as to all information the Attorney General may consider necessary. Examine under oath any person alleged to have participated in or with knowledge of the alleged pattern and practice violation, or issue subpoena or conduct hearings in aid of any investigation. Service by the Attorney General of any notice requiring a person to file a statement or report or of a subpoena upon any person shall be made. Personally, by delivery of a duly executed copy, therefore to the person to be served, or if a person is not a natural person, in the manner provided in the Code of Civil Procedure, when a complaint is filed, or by mailing by certified mail a duly executed copy, therefore to the person to be served at his or her last known abode or principal place of business within the state, or if a person is not a natural person, in the manner provided in the civil procedure. When a complaint is filed, the Attorney General may compel compliance with investigative demands under this section through an order by any court of competent jurisdiction. In any civil action brought pursuant to subsection C of this section, the Attorney General may obtain as a remedy equitable and declaratory relief, including any permanent or preliminary injunction, temporary restraining order, or other order, including an order enjoining the defendant from engaging in such violation or ordering any action as may be appropriate. In addition, the Attorney General may request and the court may impose a civil penalty to vindicate the public interest in an amount not exceeding $25,000 per violation, or if the defendant has been adjudged to have committed one other civil rights violation under this section within 5 years of the occurrence of the violation, that is the basis of the complaint, in an amount not exceeding $50,000. A civil penalty imposed under this subsection shall be deposited into the Attorney General court ordered Involuntary Compliance Payment Projects Fund, which is a special fund in the state treasury. Monies in the fund shall be used subject to appropriation for the performance of any function pertaining to the exercise of the duties of the Attorney General, including but not limited to enforcement of any law of the state and conducting public education programs. However, any monies in the fund that are required by the court or by an agreement to be used for a particular purpose shall be used for that purpose. Whew, that is a mouthful to read, but I needed to read it all because I wanted to get to this part. This actually makes me really happy, and I'll tell you why. Because where it says number 2, and it says a civil penalty imposed under this subsection shall be deposited into the Attorney General court-ordered and voluntary compliance payment projects fund. So why am I excited about that part? Well, I'll tell you why. Family court is a business. The judicial system is a business. Everybody that's coming onto these task force are going to be appointed by the government, which means that they're going to be appointed by someone else, and it's not actually elected by the people. So what I like about this is that if, from my understanding, and maybe I'm reading it wrong, and if I am, please correct me, but from my understanding, what that means is if they find somebody who is guilty of this, they're going to find that person and they're going to put the money in the Attorney General fund. So, you're probably going to ask yourself, what does that mean for me? Why is this important? Why does it mean anything? If you have a clear violation of your civil rights, okay, and I'm telling you, you're going to have documents, you're going to have proof. You have to have it, and it can't just be something that you said, but it's actual proof that there is a violation, recordings, videos, whatever. And remember, Illinois is a 2-party recording state, so if you choose to do any recordings whatsoever, you have to let the other party know unless you are in a public place. It's that simple. They are called the eavesdropping laws. You want to look them up. But if you have actual proof that something went wrong, let's say in a family court, you have a judge who violates your civil rights. You have, all of these lawyers that are violating our civil rights. GALs are violating civil rights. I mean, they're taking our children without due process. They're taking our children without actually having evidence of anything bad happening, and they're allowing our children to be abused over and over again. This is a violation of our civil rights. So, my suggestion is to anyone in Illinois who has a family court case, anyone in Illinois who has a clear violation of their civil rights, reach out to the Attorney General's office in Illinois and just ask them, file a complaint, see if they will do an investigation. Because I think if enough of us were to reach out to them and file a complaint, they would have to look at what is going on in these court systems. They would have to look into it. Because number one, they're going to have so many, they're going to be tired of it. But number two, imagine how much money they would make off of the violations that have been happening against our civil rights. How much money they would make. Now, all I'm going to say is, you decide what you want to do. But this could be a good thing. I've heard that, these public officials don't help people. I've heard these public officials don't, do anything for anyone. And I've witnessed it and seen it firsthand. So I understand the corruption. But we are talking about money. We are talking about money going back to the state. And what does Illinois love more than anything? They love money. And if they're able to get more money out of people, they're going to get more money out of people. It's just that simple. That's what they're going to do. And if they want to play games with our lives, then we need to start filing complaints. We need to come together as a group and we need to start educating ourselves and, learning our laws and who we need to reach out with and who to talk to. And we need to start demanding that our rights are being upheld and that the rights of our children are going to be upheld.